Dr.Besigye and Hajji Lutale and Captain Ola Oyadenish, who told court they have been forcibly brought from Nuzira Government Prison, appeared before High Court Criminal Division for the hearing of the treason and misprision of treason charges. Although the prosecution, led by Chief State Attorney Richard Vumbuka, was ready to commence the hearing, proceedings could not continue because the defense legal team was absent.
Of withdrawal of instructions from any of these lawyers. And actually, even the accused persons, that is A1 and A2, have equally not informed this court that he withdrew instructions from all the lawyers who are representing him since this matter started. So the assumption is that the instructions are still active. So therefore, when the accused person appears in court unrepresented the way he did last time, it's becoming habitual. And my lord, it is either
addressing court on his own behalf and on the behalf of Hajji Lutale, Dr. Besigye explained that their lawyers failed to attend court because of a pending High Court application concerning their legal representation.
Which was already in this court on the file.
Are you saying still there is a challenge to access the facilities?
Of course. So, up to today, we have not, because that is related to our legal representation. We want to hear the evidence together with our lawyers. We haven't had the opportunity to do so up to today. And I make this very clear on the file.
So, kindly be specific, the challenge with legal representation, why they are not here.
So you want to listen to the application?
So it is in that application?
It is in the application.
248.
Absolutely. That application was even touching on the earlier application, 227, where we never served the respondents.
So you are saying
that application you gave a ruling even before we served the correspondence and the respondents in that application. Application 248 was actually also seeking for substituted service so that we could serve the respondents in 227, in the application number 227, which now has already been ruled.
So you are saying that now there is that one pending, 248.
So there is application 248 pending. There is access to the disclosures, which we have never had. And we had also requested, the third issue we had requested, for a record of proceedings.
For which one? Because the records are meaningful.
A record of the proceedings so far.
In the
main case. But in the main and in the application that we have made. And regarding that, it was even part of what was presented by counsel Elias Rukwago among the 7 items that needed to be dealt with in the preliminary hearing.
So let me know those challenges you have in legal representation now. What are you requesting?
So, our request, which I made even on that.
They also informed court that they had not received any disclosures of the prosecution evidence. However, Dr. Besigye raised concern over the presentee's public remarks regarding their trial, but the court declined to entertain the submissions.
I thought you would focus on the kind of examination. I'm coming there, I don't think I'm coming there.
Disclosures which follow on the representation. And these are not new demands. They have been before this court in writing and orally.
So let me get this. The disclosures which were made to your lawyers, are you saying you want also to be made to you?
They are for us. We haven't received them because we need facilities to do so. And that's what I was complaining about last time, because we made presentations to court, they are totally ignored, and matters continue as if we did not say it. And that's why today we have said no. And we wrote a letter. Unfortunately, that letter I think also was detained by the prisons. We wrote a letter on Friday, last week, expressing further our dilemma. Having received the ruling, I think that day, saying that the hearing was to begin today. We wrote a letter on Friday. I doubt that it is yet before court. The prisons have it. So we have challenges in prison, we have challenges in court.
Prosecution objected to the submissions made by the accused.
Press or implied notice to this court that they have waived their right to legal representation of lawyers of their choice. And my lord, this act is frustrating the hearing of this matter, because the principle fair hearing, or the issue concerning hearing, is not only about the accused persons. It is about the accused persons and other parties that are involved, including the public. My lord, ever since we did our last disclosure, which I think a month or plus ago, prosecution has been ready to have this matter heard. But we have been twisted, always. And there has been a picture that has been painted to look as if prosecution is the one frustrating the trial or the hearing of this matter. We want to make it categorically clear that we have been ready to have the accused persons tried. Today we have witnesses and we came ready to have the matter heard. This in effect constitutes an abuse of the legal process. But my lord, if the accused persons are abusing the process, this court, my lord, has tools at its disposal under Section 17 of the Judicature Act.
In his ruling, Judge Emmanuel Baguma dismissed Dr. Besigye's prayers, citing the constitutional right to a fair and speedy trial. He directed the Registrar of High Court to provide the accused with a list of state brief lawyers, from which they would choose a legal representation.
We are permitted to have lawyers of their choice from day one. But since this court keeps getting concerns from the chosen persons that they have challenges with their legal representation, specifically lawyers of their own choice, this honorable court will move to look at the relevant laws. In case such a challenge keeps on, because my view is that there must be a solution for the trial to commence, and I am aware and alive of the right to the fair hearing. And my view, this case has suffered several delays, and indeed the chosen persons have said they have been in remand for some time. So this honorable court has decided to invoke Article 28(3)(e), which provides that the chosen persons are entitled to legal representation at the expense of the state in the cases of any offense which carries a sentence of death or imprisonment, life imprisonment. In the view of the above, the registrar criminal division is directed to avail a list of all lawyers in the criminal division for all the state brief, which criminal division has a pool of lawyers on state brief. So in order for the chosen persons not to suffer with the challenges of the legal team which keeps coming, the registrar should avail to the chosen person that list of all lawyers on state brief in the criminal division. And then this list should be given to the chosen persons through Zira, for the chosen persons to look at this rule and choose as the fallback, choose some lawyers of their choice for the purposes of this trial. And this, the registrar is directed to do it by tomorrow 14th and send this list to Zira through the prison officers, so that the chosen persons can look at this list of lawyers and be able to choose from them the lawyers of their choice. And this doesn't stop any other lawyer of the choice of their chosen persons to join the team of state lawyers, on the state brief. So the chosen still has a right to get lawyers of their choice, but in order for this trial to have a direction, let us have a list of lawyers on state brief from criminal division, selected, chosen by the chosen persons themselves. In alternative,
Judge Emmanuel Baguma further ordered the prosecution to disclose all evidence to both the accused and the state brief lawyers selected to enable the case to proceed without unnecessary delay.
in this case and in other applications, I'm directing the Registrar of Criminal Division to avail the copies. In any case, the proceedings are by transcribing. So the IT should help the registrar to have these proceedings in this main case and applications, so that the registrar can certify them and serve the chosen persons. This one can be done by tomorrow, which is 14th. And let the registrar, the IT, together with Luzira prison, they should get these proceedings and arrange them to the chosen persons. We will now proceed to the facilities.
The court also ruled that any private lawyers selected by the accused may work alongside with the state belief selected lawyers. Court will resume on 15th July 2026 for mention of the case. The accused Dr. Besigye, Hajji Lutale and Captain Ola Oyadenish were further remanded to Luzira Government Prison.